Welcome everyone, this is Amer from UCounsel. In today's lecture we'll talk about service of court documents in Ontario. This lecture deals specifically with matters, proceedings in the Superior Court of Justice in Ontario, does not deal with matters that relate to small claims court. However, the rules relating service are quite similar in small claims court and in Superior Court, so you will benefit from this lecture even if your matter is in small claims court. Now, this topic has come up a few times. I had interactions with some of you who had specific questions about service of documents in their own proceedings, and then I ended up dealing with this matter in one of my own court cases where, on behalf of my client, I had to bring a motion to the court and ask for a relief on substituted service, not something that we'll cover today, but it has become an important topic, so I thought it'll be prudent to cover it now. We begin with our usual disclaimer that this course is not legal advice, so if you have any specific questions regarding your issues, you should contact a lawyer or a paralegal or contact the Law Society of Ontario to get a referral. Now, there are different types of court documents, and some of these documents are statement of claim, notice of action, notice of application, statement of defense, counterclaim, third-party claim, cross-claim, reply, affidavit of documents. So these are all documents that are referred to in the rules of civil procedure in Ontario. And so how do you serve those documents on different parties? That is all specified in the rules of civil procedure. But we're going to focus today on the service of originating process, which is the most important topic, and why we're going to talk about originating process. We'll cover that. Let me explain what an originating process is. And this is covered under Rule 1.03 sub 1. There are specific documents that are considered documents of originating process: statement of claim, obviously, notice of action, notice of application, an application for a certificate of appointment of an estate trustee, a counterclaim against a person who is not already a party to the main action, and a third party or subsequent party claim. If you go to on Google, if you go to the rules of civil procedure, I've opened it right here under Rule 1.03 sub 1. This is defined. The originating process is defined here, and so these are specific documents that are listed here, and they constitute originating process. Now, why do you need to effect proper service for the originating process? Why is this so important? I think you can understand from the nature of these documents that these are the documents, originating process documents are the ones that actually start a court proceeding. So if it's a claim, then it's starting a court action. If it's an application, then it's starting an application. So an originating process is the very first document that allows you or a party to commence a proceeding in the Superior Court. Now, there is a separate process of going to court, filing your statement of claim, getting the court file number, and having it issued. Once that document is issued, the rules require you to serve that originating process, that statement of claim, that notice of action, onto the other parties, because then the parties involved would know that they are involved in that proceeding, and then they have an opportunity to defend themselves or defend their position in that proceeding. If the originating process is not served on any of the parties, then one of the situations that may arise is that the defendant or a respondent may not even know about a proceeding. So put yourself in the shoes of a defendant. If someone commences a court action against you, for example, the allegations may be that your dog may have bit that person and that person brought a court action against you for certain damages. That person goes into the court, files a statement of claim, gets that issued. But if you don't know that there is a court action against you, you have no opportunity to defend yourself. And if you're not participating in that proceeding, then what can happen is the applicant or the claimant has the opportunity to seek default remedies, because there are specific timelines, and if you have not responded, if you have not filed your statement of defense or other court documents that are necessary to participate in that court proceeding, then after the timeline is over, the applicant or the claimant can go to the court and say that the defendant or the parties, the respondents or the defendants, have not participated, have not filed their statement of defense, and I want a default judgment against those individuals or those parties. And once the claimant or the applicant can get a default judgment, then they can proceed to have the enforcement of that default judgment. So it's a pretty significant remedy for an applicant to proceed absent a defendant or respondent participating in the court process. So because the applicant can go and get a default judgment, the courts are very concerned about issuing or granting default judgments when there is no defendant or respondent present. Because ideally what courts like is all the parties to show up, all the parties to present their positions to the court, present the evidence, and then the court can decide who is right and who is wrong. But if there's only one party before a judge, before the court, and the other party is not present, then the natural question that arises in court's mind is that whether that party knows that there is a court action against that party. And so when you proceed with a motion for default judgment, default remedies, then the court is going to examine how you conducted the service of your originating process. So the court's going to look at the rules, and the court is going to look at what actions you took to serve those documents. And if you did not take the steps that were required by the rules of civil procedure, the court will send you back and will not grant you the remedy that you're asking for. So that is why it is most important that the originating process is served properly and you are aware of all the rules that are imposed with respect to the service of the originating process. Now, Rule 16 of the Rules of Civil Procedure is the one that specifically deals with service of all kinds of documents, and Rule 16.01 deals with the service of originating process. So 16.01 basically says that an originating process can be served personally or by alternative to personal service. So we'll look into briefly what is meant by a personal service and what is meant by an alternative to personal service. Personal service is specified in Rule 16.02. When you read those rules, and I'll take you there and we'll quickly go through the rules on the website, but the rules are very specific. They have specific requirements if you are to service the document on an individual, a municipality, a corporation, a minor, a mentally incapable person, a crown, a person who is absent. So there are different kinds of parties based upon their circumstances, and there are different obligations on you to ensure that the service is properly effected on these parties. Now, for example, if you're serving the originating process on an individual, the easiest way of doing a personal service is by leaving a copy of the document with the individual. And we see this often being played in the movies when someone is sitting at a restaurant and a person comes in and approaches them and addresses them and confirms their identity. Are you so-and-so, Mr. So-and-so? And the person says yes. And the other person hands over a document saying you have been served. Now, you don't have to, in Canadian jurisdiction, say the wording you have been served. You just need to provide the document. And then also some of the nuances of this is that it is not necessary for that person to take the document from your hand. That's not your obligation. So if the person refuses to take the document, you can just leave it in front of that person on the table, on ground, and just walk away. You're not required to ensure that the person accepts that document from your hand. As long as you've confirmed the identity and you have either handed over the document or left it in front of that person and walked away, that will be sufficient in terms of a personal service on an individual. With respect to corporation, you can serve the originating process on an officer, director, or agent of the corporation, or with any person at any place of business with the corporation who appears to be in control or management of that business. Now, so obviously if you know the identity of the officers or directors or agents of the corporation, you can serve it on them. Otherwise, the common practice is that you go to one of the offices of the corporation, and if they have a reception, you serve it at the reception, and that will generally be considered sufficient personal service. Now let's go down to Rule 16.01 so that we can have a quick look at. So as I mentioned, 16.01 basically says that originating process shall be served personally or by an alternative to personal service. And if you scroll down, 16.02 is the one that I just briefly went over, and then it talks about how to serve an individual, municipality, corporation, board or commission, person outside Ontario, carrying on business in Ontario, Crown and Right of Canada, Crown and Right of Ontario, Attorney General, absentee, minor, mentally incapable person, partnership, sole proprietorship. So all of these categories are specified here, and if you are dealing, the common ones are individuals or corporations, but if you are dealing with an entity that is not one of those two categories, then you need to review the specific rules and then understand and follow them. Alternative to personal service is under Rule 16.03. Let's quickly look at that rule. So alternative to personal service obviously means that if you could not effect personal service, then you have an option to do it by alternative means. So one of the alternative means is that you can serve the document, the originating process, at the place of residence of that person. If you scroll down, service at place of residence, right? So where an attempt is made to effect personal service at a person's place of residence, and for any reason personal service cannot be effected. So the person is not there that you want to effect service to, and you're unable to serve that person personally, the document may be served by leaving a copy in a sealed envelope addressed to the person at the place of residence with anyone who appears to be an adult member of the same household. It cannot be a person who's minor. You cannot serve it on them. You can serve it on the person's spouse or parents, but any adult member who appears to be belonging to the same household. So that's step number one, in a sealed envelope. Then on the same day or the following day, by mailing another copy of the document to the person at the place of residence, and service in this manner is effective on the 5th day after the document is mailed. So there are basically two steps. If that person is not present at the residence, you leave it with an adult member of that household, and then the next day you have to send another copy by mail to the same place of residence. If you don't follow the step number 2, then the service will not be effective. So that's an example of effecting service at the place of residence. Another example could be acceptance by a lawyer. So if, for example, if you are serving documents on one of my clients and you can't locate my client, or you wish to serve it on me because you know that I'm the lawyer, then you contact me and you say that I am willing to serve the document on you as their lawyer. But then important to note that I need to confirm to you that I have the authority to accept the service on behalf of that client, because that person, that party may be my client on other matters, but I may not have the authority to deal on behalf of that client on the specific matter that you are dealing with. So the acceptance by the lawyer is important. Unless the lawyer is already a lawyer on record, in the court record, then you don't need to have a specific approval from the lawyer. Another example of alternative service is last known address. Once you know the last known address of the person, you can effect service there. Let's look at, here you go, service by mail to last known address. Service of a document may be made by sending a copy of the document together with an acknowledgement of receipt card, Form 16A, by mailing to the last known address of the person to be served, but service by mail under the subrule is only effective as of the date the sender, which is you, received the card. So what this means is when you're mailing it to the last known address, you send the card, the person accepts, signs the card, sends it back to you, and when you receive it, only then the service is effective. That's now generally. But with respect to service on a corporation, you can find out the last known address of the corporation from the Ministry of Government and Consumer Services. You go to the ministry, there's a branch in downtown, and go there, and then you get what's called the corporation profile report, and that will indicate the last address that is recorded in the government records of that corporation. And if you mail that document, the originating process, on that record, then the service will be effective. Now it can get complicated, and as I mentioned, that the service of originating process is crucial. It's very important. You need to make sure you do it properly. There are organizations, companies called process servers. These are companies that are specialized in serving court documents. That's what they do all day long. So you can always Google them, find one in your jurisdiction, contact them, and ask them to effect service on your behalf. And that maybe it will be a little bit of a cost to you. It's not significant. So I think that may be an easier way to ensure that the documents are properly served, and the process servers know that once they have effected the service, they will provide you with an affidavit of service. So they will do the whole thing, and you will not have any issues if you have to appear before the court to prove the service of documents. Now, a topic that I've not covered, I alluded to in the beginning, is something called substituted service or dispensing with the service. So what if you tried all of these things and you were still not able to serve? You can actually, under Rule 16.04, bring a motion before the judge, get an order for substituted service, so meaning other ways of effecting service that you think will bring the originating process to the knowledge and attention of the parties, or completely dispensing with the service. There may be circumstances where you believe that service simply cannot be effected and you want the court to dispense with it. And in that case, you'll have to bring a motion and you'll have to explain to the judge why you couldn't do personal service or alternative to personal service, and why substituted service or dispensing with the service is appropriate. There may be circumstances where you may be able to show to the court that the effective way of serving is by email, by Facebook, Twitter, Instagram account. The motion that I recently brought, I was able to explain to the judge why email service will bring the originating process to the attention of that party, and the court granted me that permission. So you have to explain, it has to be a reasonable position, it needs to make sense, and then the court will grant you the remedy. Now, service on lawyer who's not lawyer on record for this proceeding. So as I mentioned, if I am a lawyer for that party but not on this specific matter, then you can, and I refuse to accept service, then you can bring a motion and explain to the judge that, you know, Mr. Mushtaq is counsel for that party in an existing proceeding, so he's obviously in contact with that party, and I want the court to order that if we serve on Mr. Mushtaq, this will be an appropriate service and should be accepted. So that's also a possibility, that you can get court's permission to serve on a lawyer that you know is in contact with that party and will be able to communicate your originating process to the party. So in conclusion, you need to carefully review Rule 16. I've shown you some parts of it, but depending upon your circumstances, you want to make sure that you review it, you understand it, and then you ensure that the service is effected pursuant to the rules of civil procedure, and then you ensure that you have the proper affidavit of service. It is prepared and it's ready. If you need to bring a motion for the court for default judgment, the court is going to ask you, how did you effect service, and whether you have an affidavit of service if it was not you and someone else who effected service. Thank you for listening. Thank you for watching. And if you have any specific questions on this topic, please do not hesitate to send us an email or contact us, and we'll be happy to address that in another lecture.